please rise for the Constitutional Court? I call the matter of Jacob Zuma and Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including levels of state and others. Judgment.
Justice, as the court pleases, I appeal the applicant compliant with this one.
Yes, your name? Madikofa. Thank you very much, ma'am.
Please the court, Justice Gampepe. I'm Johan van Skalkwyk from State Attorney Johannesburg, appearing for first and second respondents, as the court pleases.
Thank you, sir. Today,
As the court pleases, my name is Dakaro Singo. I appear on behalf of the First Amicus Curiae, the Council for the Advancement of the South African Constitution.
Thank you, Mr. Suko. Today, the Constitutional Court hands down judgment in an application brought by former President Jacob Zuma, in which he asked the court to rescind and set aside the judgment and order it handed down on 29 June 2021. In terms of that order, Mr. Zuma was found guilty of contempt of court for his failure to comply with an earlier order of the Constitutional Court and was sentenced to direct imprisonment for a period of 15 months. The present matter arises from a series of applications that have traversed the role of the Constitutional Court over the last year, and it is necessary that I briefly set out the historical background to contextualize this matter. In December 2020, the Secretary for the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, which is the first respondent in the present matter, approached the Constitutional Court on an urgent basis for an order that would compel Mr. Zuma's cooperation with the Commission's investigation. Mr. Zuma did not oppose the application. On 28 January 2021, the Constitutional Court handed down judgment ordering Mr. Zuma to attend the Commission and give evidence before it. Notably, Mr. Zuma did not comply with that order. Instead, he issued a series of public statements in which he impugned the integrity of the court, the Commission, and the judiciary, and expressed an intention neither to cooperate with the work of the Commission nor comply with the order. In February 2021, in response to Mr. Zuma's non-compliance, the Secretary of the Commission approached the Constitutional Court again on an urgent basis and launched contempt of court proceedings, seeking a punitive order in Mr. Zuma's imprisonment. Once again, Mr. Zuma elected not to participate in the proceedings. Unanimously, the Constitutional Court found Mr. Zuma guilty of the crime of contempt of court. However, two judgments were penned that reached different conclusions on the issue of the appropriate sanction for Mr. Zuma's contempt. In determining the appropriate sanction, the majority took stock of the aggravating factors which characterized his contempt. In the unprecedented circumstances that Mr. Zuma's contumacy had created, the majority found that the appropriate sanction capable of vindicating the dignity of the Constitutional Court and safeguarding the rule of law was a punitive sanction in the form of direct and unsuspended committal. The majority held that a coercive order that uses the threat of imprisonment to compliance with the initial order would have been both futile and inappropriate. On this, the minority judgment diverged. It concluded that it would be unconstitutional to grant an order of unsuspended committal in the context of motion proceedings for civil contempt of court where committal is not aimed at coercing compliance with the initial court order. The majority emphasized that although civil contempt proceedings are not a conventional criminal trial and a contemner is not an accused person as contemplated by Section 35 of the Constitution, which affords accused persons certain rights, the majority accepted that a contemner remains entitled to his or her rights in terms of Section 12 of the Constitution. Section 12 entrenches the right not to be detained without trial. In recognition of this, the Constitutional Court invited Mr. Zuma to make submissions on mitigation of sentence in the event he were to be found guilty of contempt of court. And after considering the procedures followed in that matter, the majority concluded that Mr. Zuma's constitutional rights had not been infringed. The minority judgment took a different view, concluding that the procedure adopted by the majority unjustifiably compromised Mr. Zuma's constitutional rights. In any event, instead of furnishing the court with mitigating factors, Mr. Zuma squandered the opportunity, once again refusing to participate and electing instead to air inflammatory statements in which he impugned the integrity of the judiciary. Absent Mr. Zuma's submissions on sentence, the majority considered what would be capable of vindicating the authority of South Africa's apex court, while sending a general message that orders made by a court must be obeyed, and to Mr. Zuma specifically, that his contempt was rebukable in the strongest sense. The majority ordered that he be sentenced to imprisonment for a period of 15 months. In anticipation of his impending incarceration, Mr. Zuma filed an application for direct access on Friday, 2 July 2021, seeking the rescission or reconsideration of the order that demanded his imprisonment. I should explain that, of course, whilst an order of the Constitutional Court cannot be appealed, our law does make provision for an order, even one of the Constitutional Court, to be rescinded in narrow circumstances where, for example, it can be proven that the order was made in a party's absence and that an error was made by the court that granted it. It is on this basis that Mr. Zuma brought the present application. In terms of the impugned order, however, Mr. Zuma was incarcerated on Wednesday, 7 July 2029. The matter was heard by the Constitutional Court on an urgent basis on Monday, 12 July 2021. The parties in this matter are as follows. The first respondent is the Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption, and fraud. The second respondent is Raymond Nyamaiseli Zondo, cited in his official capacity as the chairperson of the commission. The third respondent is the Minister of Police, who was cited as a respondent in contempt proceedings for purposes of securing Mr. Zuma's arrest and committal. The fourth respondent is the Minister of Justice and Correctional Services. No relief is sought against the third and fourth respondents. The Helen Suzman Foundation, in brackets HSF, admitted as amicus curiae in contempt proceedings, is cited here as the fifth respondent. To begin with, Mr. Zuma submitted that the jurisdiction of the Constitutional Court is engaged and that his applications meet the requirements for direct access because no other court would have jurisdiction to rescind an order of the apex court. The thrust of his case was that the majority judgment in the contempt of court proceedings constitute as serial manifestations of rescindable errors or omissions susceptible to rescission in terms of Rule 42, Subsection 1A of the Uniform Rules of Court, and the common law. He submitted that the portions of the order in terms of which he was found guilty of contempt and incarcerated should be rescinded or set aside. First, he submitted that the order was granted in his absence, since he had not participated in the proceedings, which he averred was justified given that he could not have been expected to comply with the order that required him to appear before a commission of inquiry that he felt was biased against him. He alleged errors in the granting of the order, which include that the commission sought an order securing his imprisonment by way of motion proceedings, rather than seeking to ensure his attendance at the commission by invoking the Commissions Act, that the Constitutional Court took account of his public statements, which constituted hearsay evidence, that the court targeted him with an exceptionally harsh, tailor-made sanction, and that acting Justice Pillay, with whom he took issue, formed part of quorum in contempt proceedings. All of the above, he concluded, constitute grounds for a rescission in terms of Rule 42, subsection 1A. And in the event that he has not met those requirements, that he has established good cause for a rescission under the common law. Mr. Zuma also argued that the order and judgment were unconstitutional. According to Mr. Zuma, the granting of the impugned order breached several of his fundamental rights, most notably those contained in sections 12, 34, and 35 of the Constitution, and that the majority erred in failing to conduct a limitations analysis in order to determine whether those encroachments on his rights were justifiable. He averred that he was summarily sentenced without a trial and without being afforded an opportunity to advance mitigation after his conviction. And he maintained that Rule 42 of the Uniform Rules of Court is incorporated into the rules of the Constitutional Court by Rule 29, which explicitly incorporates it with such modification as may be necessary. This particular phrase is important because he submitted it has the effect of bringing the meaning of a rescindable error within the constitutional framework. Accordingly, Rule 42 must be interpreted so as to include situations where a court grants an unconstitutional order, and on this basis, the order should be set aside for it is unconstitutional. Finally, he concluded it would be in the interest of justice for it to be rescinded and set aside. The Commission argued that the application falls to be dismissed with cause since it does not meet the legal requirements for rescission and lacks prospects of success. Simply because Mr. Zuma elected not to participate when he was entitled to do so and had access to legal representation cannot mean that the order was erroneously granted in his absence. Furthermore, all of the grounds advanced by Mr. Zuma were unmeritorious and incapable of establishing errors. According to the Commission, Mr. Zuma's arguments are merely his delayed defense to the contempt case and are irrelevant in a rescission application. However, notwithstanding that Mr. Zuma failed to advance these arguments, the Constitutional Court dealt with them in any event, so it cannot be opened for the Constitutional Court to revisit those arguments in this rescission application. To do so would fly in the face of the doctrine of functus officio, according to which a court that has pronounced on an issue has discharged its function and does not have the authority to alter, correct, or set it aside. The Commission emphasized the importance of finality in litigation, without which the rule of law is undermined. The HSF submitted that not only did Mr. Zuma preempt his right to bring this application, when he made a calculated decision to abstain from the proceedings, he has also failed to meet the requirements of Rule 42. HSF stressed that the rule applies to instances where an adverse judgment is erroneously made against a party who is absent, but does not offer recourse to a party who, with proper notice of the case, nevertheless refuses to participate. It submitted that the order was not erroneously granted, nor expanded tests for rescission should be developed in these circumstances, and Mr. Zuma is essentially asking the court to reevaluate the constitutionality of its contempt court order, which HSF submitted is not a ground for rescission. According to HSF, this application is an attempt to ask the Constitutional Court to revisit the merits of contempt proceedings, which issues it has already dealt with. Thus, this application is an affront to the principle of functus officio and res judicata, and challenges the principle of finality of litigation. Council for the Advancement of the South African Constitution, CASAC, and Democracy in Action, DIA, applied to be admitted as amici curiae. The nub of CASAC's submission was that legal certainty and the credibility of the legal system depend on litigants' acceptance of judgment as final. CASAC submitted that the rule of law is especially undermined in instances like this, where a litigant brings a rescission application expecting relief after adopting an intentional legal strategy of difference. CASAC emphasized that there are deliberately narrow circumstances in which a judgment and order can be rescinded, and that Mr. Zuma has not met the requirements. The crux of DIA submission concerned the question of fair trial rights and the far-reaching implications of ordering an unsuspended custodial sentence for the crime of civil contempt of court in the absence of ordinary criminal procedure. DIA was of the view that the majority of the Constitutional Court infringed Mr. Zuma's rights in terms of Section 12 and 35 of the Constitution. Accordingly, the judgment and order are unconstitutional and fall to be set aside. Satisfied that CASAC and DIA met the requirements for admission as amici curiae and advanced useful submissions that differed from those already advanced, the Constitutional Court admitted CASAC and DIA. In this matter, 3 judgments have been penned. The majority penned by myself, with Madlanga J, Majid J, Mhlantla J, Pile AJ, Tlaletsi AJ, and Shikil J concurring. A dissent penned by Jafta J, and a 3rd judgment penned by Theron J, concurring in part with the 2nd judgment. I shall begin with the findings of the majority of the Constitutional Court. As with all matters that reach the Constitutional Court, I must begin by disposing of the question of jurisdiction. Intuitively, jurisdiction is engaged and direct access is granted. It would be inappropriate for any other court to entertain an application to rescind an order made by the Constitutional Court. And although direct access is only granted in rare and exceptional circumstances, Rule 42, subsection A would never find operation in respect of an order of the Constitutional Court without direct access first being granted. Mr. Zuma has his foot in the door. The real question, however, is whether Mr. Zuma has met the jurisdictional requirements for rescission in terms of Rule 42, subsection 1A, or the common law, or whether he has established that it is in the interest of justice for the court to exercise its discretion to rescind the order it granted. Beginning with Rule 42, subsection 1A, the majority of the Constitutional Court finds that Mr. Zuma has not met the statutory requirements of a rescission. Rule 42 stipulates that a court may rescind or vary an order or judgment erroneously sought or erroneously granted in the absence of any party affected thereby. It is trite that an applicant who invokes this rule must show that both grounds exist. Far from persuaded by Mr. Zuma's submissions, the majority finds that although Mr. Zuma's physical absence cannot be disputed, the words granted in the absence of any party affected, as they appear in Rule 42, exist to protect litigants whose presence was precluded, not those whose absence was elected. Mr. Zuma was given notice of the contempt of court proceedings launched against him. He knew of the relief the Commission sought. Despite this, he elected not to participate. The majority emphatically reject any suggestion that litigants can be allowed to butcher of their own will judicial process which in all respects has been carried out with the utmost degree of regularity, only to later plead the absent victim. Elected absence, like that of Mr. Zuma, constitute more than litigious skullduggery, which does not have the effect of turning a competently granted order into one erroneously granted. It is quite simply not for these sorts of circumstances that the law of rescission caters. Mr. Zuma's purported absence is not the only respect in which his application fails to meet the requirements of Rule 42, subsection 1A. The majority finds that he has also failed to demonstrate why the order was erroneously granted. An applicant must show that the judgment against which the rescission is sought was erroneously granted because there existed a fact of which the court was unaware at the time, which would have precluded the granting of the judgment had the court been aware of it. It is not the case that the absence of submissions from Mr. Zuma, which may have been relevant that the court was seized with contempt of proceedings, can render erroneous the order granted on the basis that it was granted in the absence of those submissions. Indeed, it is a tried principle of the law of rescission that the existence or non-existence of a defense on the merits is an irrelevant consideration, and if subsequently disclosed, cannot transform a validly obtained judgment into an erroneous one. Mr. Zuma had multiple opportunities to bring these arguments to the attention of the court. That he opted not to cannot mean that the court committed an error in granting the order. In any event, the majority finds that the ground advanced by Mr. Zuma as rescindable errors are devoid of merit and, in fact, are issues that the Constitutional Court has already disposed of when it dealt with contempt proceedings and thus have no place in a rescission application. As an alternative to Rule 42, Mr. Zuma pleaded rescission on the basis of the common law, in terms of which an applicant is required to prove that there is sufficient or good cause to warrant rescission. It is well established in our jurisprudence that to prove sufficient cause for rescission, an applicant must furnish a reasonable and satisfactory explanation for his or her default. He or she must then show that on the merits, he or she has a bona fide defense which carries some prospect of success. It is imperative that I emphasize that both of these requirements must be met. What this means is that Mr. Zuma must establish that he had a reasonable and satisfactory explanation for his failure to oppose the contempt proceedings and in addition that he has a bona fide case that carries some prospects of success. The Constitutional Court concludes that Mr. Zuma has failed to meet these requirements. Not only does his application lack prospects, all of his submissions having already been disposed of, he has failed to provide a plausible and acceptable explanation for his default. That he may have taken issue with the profile of the Commission is of no moment, and allegations of bias in respect of its chairperson cannot justify his absence from proceedings in the Constitutional Court. To his peril, Mr. Zuma declined to participate in the contempt proceedings and disdainfully dismissed a further opportunity when invited to do so. He only attempts to justify his absence now that the shoe pinches. He cannot hope to succeed on the merits for, as outlined already, an unsatisfactory explanation remains so, whatever the prospects of success on the merits. This is not the end of the story. Mr. Zuma submitted that if he failed to establish the requirements for rescission under Rule 42 or the common law, then the Constitutional Court should nevertheless reconsider its order on the basis that the meaning of a rescindable order should be expanded to permit for rescission where a litigant impugns the constitutionality of the order. The position Mr. Zuma advocates necessarily involves the broadening of grounds for rescission. So the court is seized with the question whether it should indeed expand the grounds for rescission. The majority finds that far from inviting courts to expand the scope of rescission, our jurisprudence suggests we must do the opposite. The legislature has deliberately carved out exceptionally narrow grounds of rescission because the very notion of rescinding a court order is an affront to the rule that orders, especially those of the apex court, are final. This, the Constitutional Court emphasizes, is important because if orders of court are too readily set aside, the administration of justice would be compromised by chaos. Despite Mr. Zuma's creative attempts to have the order set aside, the majority of the Constitutional Court finds that the qualification Rule 29 of such modifications as are necessary provides no panacea to this ill-fated application for rescission. If the Constitutional Court were to adopt a generous approach in construing Mr. Zuma's case, it might be open to it to reconsider its order if it would be in the interest of justice to do so. Because the second judgment finds that this is what ought to be done in these circumstances, it is necessary to pronounce on this. The majority finds that although there may be circumstances in which the interest of justice require rescission, those circumstances must be wholly exceptional to justify a departure from the res judicata doctrine. And there is nothing in Mr. Zuma's case that can be construed as truly exceptional to the extent that the court should depart from the underlying principle and ordinary tenets of the rule of law. Far from causing a grave injustice if the court refuses to consider its order, the administration of justice would be brought into dispute if this court were to reconsider it. Having established that the interests of justice do not compel the majority to expound the grounds of rescission or reconsider the application, the majority emphasizes that the interest of justice requires the Constitutional Court to protect the principle of finality in litigation. It is precisely to protect this principle that orders of the Constitutional Court are immune from appeal and that the doctrine of functus officio binds courts. Of course, Rule 42 creates an exception to that doctrine, but only in narrow circumstances. The majority finds that the court is functus officio in respect of the grounds advanced by Mr. Zuma, and that it would not be in the interest of justice to relax this doctrine or expand the grounds upon which a rescission can be sought. To do so would be to dismember the rule of law. Finality and legal certainty are the linchpins of the interest of justice inquiry, and the uncertainty that has shrouded this application has already done untold damage to the rule of law and those principles that underlie it. In navigating the interest of justice inquiry, the majority finds that Mr. Zuma's conduct is also relevant. The Commission and HSF argued that he preempted or waived his right to bring this application as his conduct indicated that he was not in the least concerned with what decision the court might reach. The principle that underlines the doctrine of preemption is that no person can be allowed to take up two positions inconsistent with one another, to blow hot or cold, or to appropriate or reprobate. While it is not wholly fair to state that Mr. Zuma acquiesced in the judgment by acting in a manner synonymous with an intention to abide by it, after all, he did launch this application, the majority finds that the underlying principles of preemption resonate. Mr. Zuma's behavior, albeit made manifest before the judgment and order were handed down, pointed indubitably to the conclusion that he had resigned himself to any decision that the court might make. With this in mind, to entertain Mr. Zuma's application in these circumstances would be to permit him to blow hot or cold. It would fly in the face of the interest of justice for a party to be allowed to willfully refuse to participate in litigation and then expect the opportunity to reopen the case when it suits them. It is simply not in the interest of justice to tolerate this manner of litigious vacillation. The majority of the Constitutional Court is also not persuaded by the reasoning of the second judgment, which I shall come to momentarily. The second judgment concludes that the impugned order and the effect of authorizing Mr. Zuma's detention without a trial in contravention of Section 12, subsection 1b of the Constitution, and that the procedure leading up to his conviction and sentencing breached his rights guaranteed by Section 35 and Section 35, subsection 3 of the Constitution. The second judgment contends that the determination of these issues depends on the proper interpretation of the Constitution, which requires recourse to international law. Particular emphasis is placed on Article 9 and 14, subsection 5 of the International Covenant on Civil and Political Rights, in brackets called ICCPR. Article 9 guarantees the right to liberty and security of the person, including the right not to be detained unlawfully, whilst Article 14, subsection 5 provides for the right to have one's conviction and sentence reviewed by a higher tribunal. The second judgment maintains that the judgment and order are not only unconstitutional, but are not compliant with international law, which renders the order rescindable. The majority accepts that it is incontrovertible that the Constitutional Court, like all South African courts, is constitutionally enjoined by Section 39, subsection 1b of the Constitution to consider international law when interpreting the rights in the Bill of Rights. This is an interpretive injunction, however, and does not oblige any South African court to prefer a position taken in international law as the second judgment suggests. The majority emphasizes that the status of international law must not be mischaracterized. Furthermore, the majority disputes the relevance of the ICCPR to a rescission application launched in a South African court. Firstly, it must be emphasized that in a dualist legal system like South Africa's, international treaties do not create rights and obligations capable of being enforced domestically unless they are incorporated by an act of parliament. The ICCPR has not been incorporated and therefore only binds South Africa at international level. Its provisions cannot be invoked by litigants in our domestic courts. Thus, any alleged incompatibility with its provision simply cannot constitute grounds for rescission or reconsideration in a domestic court, including the Constitutional Court. Finally, the majority emphasizes that the doctrine of subsidiarity, crystallized as a structural principle of international law, recognizes the need to defer to domestic approaches to implementing international law. Accordingly, the majority finds that the degree of reliance placed on the ICCPR by the second judgment is misguided. This is a relatively straightforward matter. Mr. Zuma has met neither the requirements of a rescission in terms of Rule 42, subsection 1A, nor the requirements of one as governed by the common law. Mr. Zuma is seeking to reopen the merits of the contempt proceedings which have been disposed of already. And it is contrary to interest of justice to recall that matter to life by expanding the grounds of rescission and reconsidering the judgment and order handed down on 29 June 2021. It is unfortunate, to say the very least, that Mr. Zuma failed to bring the submissions with which he now arms himself to the Constitutional Court before we reach this point. For all that can be said is that the predicament in which he now finds himself is not the making of the courts, nor does the solution lie with the courts. The hands of the Constitutional Court are bound, and Mr. Zuma himself bound them. It must, of course, be emphasized that rescission is an avenue of legal recourse, remains open, but only to those who advance meritorious and bona fide applications and who have not at every turn of the page sought to abuse judicial process. On a conspectus of all of the above, the conclusion of the majority of the Constitutional Court reaches is that this application falls to be dismissed with cost. The second judgment, penned by Jafta J, with Jaron J concurring, finds that the issue for determination is whether the motion procedure followed when Mr. Zuma was convicted and sentenced complied with Section 12, subsection 1B, which guarantees the right not to be detained without a trial. The second judgment interprets this section and concludes that it requires a trial to be held before an individual may be detained. Since here there was no trial, the second judgment concludes that the detention was invalid as it was inconsistent with Section 12, subsection 1B of the Constitution, unless it constituted a reasonable and justifiable limitation. Having undertaken the justification analysis, the second judgment concludes that the limitation was not justifiable. Accordingly, the second judgment holds that the detention was unconstitutional and invalid. The second judgment, with reference to Section 172(1) of the Constitution, points out that the Constitutional Court is obliged to declare the detention invalid and set it aside. It points out that the invalidity of the order flowed from its being inconsistent with the Constitution. Theron J concurs in Jafta J's judgment, subject to the qualification that there is no need to craft a separate ground for intervention. Theron J holds instead that on the basis of Mlawuzi versus S, an order of the Constitutional Court can be reconsidered in exceptional circumstances and where the interest of justice cries out for intervention. Theron J agrees with Jafta J that the order made by the majority in the contempt proceedings was made pursuant to an unconstitutional procedure. Theron J holds that the Mulauzi test is thus satisfied because Mr. Zuma was incarcerated on the basis of an unconstitutional procedure and importantly without a right of appeal, meaning that his case is truly exceptional and cries out for intervention, failing which he will be visited with substantial hardship and injustice. In the result, the majority of the Constitutional Court makes the following order. 1, direct access is granted. 2, counsel for the advancement of the South African Constitution and democracy in action are admitted as amici curiae. 3, the application for rescission is dismissed. 4, Mr. Jacob Zuma is ordered to pay the cost of the Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, and Raymond Mnyamezeli Zondo, NO, including the cost of 2 counsel. I hand down the judgment.
Please rise.
Well, it certainly is a bad day at the office for Jacob Zuma's legal and defense team as his application to rescind his incarceration is dismissed with costs. And the majority court found that orders of the Constitutional Court are, immune from appeal. And the principle of finality of litigation is, of course, the linchpin of the judiciary. Well, Jacob Zuma has been found not to have met the statutory requirements of a rescission, and Justice Zisicampempe there dismissing an applicant's butchering the judicial system for their own gain. Well, Justice Zisicampempe delivering the Constitutional Court judgment on the rescission application by former President Jacob Zuma, and she first gave an overview of the history of the Jacob Zuma case. And on the issue of overturning the order of the Constitutional Court, Justice Kampepe said that an order can be overturned in the form of a rescission only in the narrow circumstances such as an order being granted in the applicant's absence. She submitted that Zuma's application flies in the face of the what she called the functus officio principle, suggesting the principle of finality of litigation, as it is in the public interest that litigation be brought to finality. Well, breaking news this hour. The Constitutional Court has dismissed former President Jacob Zuma's application to have his incarcerated set aside, and will bring in more analysis onto this matter. But for now, let's bring in Samgela Masego, who's been following up on this story.